the family of Mr. Ram Jethmalani, who is assembled here from near and far, Mr. Arjun Meghwal, the Union Minister for Law and Justice, Mr. R. Venkatramani, the Attorney General for India, my very distinguished Chief Justice, Justice Dipak Misra, Mr. Fali Nariman, Mr. Shyam Diwan, Mr. S. Gurumurthy, members of the bar and everyone present here. I'm quite overwhelmed, honestly, to be speaking about Ram Jethmalani, whose legacy continues to resonate in the hearts and minds of people across India. Yesterday was his 100th birth anniversary. It is not every day of our lives that we get the opportunity to celebrate the legacy of such great human beings. And honestly, I thought I should say a few words about him. Because for the younger generation, many of whom have not witnessed the years that we have to ask ourselves, how do you clone a Ram Jethmalani? And can we really clone Ram Jethmalani? Possibly no, because to clone Ram Jethmalani, we'll have to clone the social and the historic and the political times in which he grew and flourished and evolved as a human being. He donned many robes. He was India's top criminal lawyer, unquestionably so. He was an acclaimed parliamentarian, elected as a member of the Lok Sabha twice and of the Rajya Sabha once. Ram's legacy endures not only because of his unparalleled mastery over the law, but also due to his relentless pursuit for justice through legal and constitutional means. He lived in times when one could be despondent about the way in which things were turning out after independence. But he never gave up his pursuit, his faith, his belief in the Constitution, in the law, as a means of bringing out orderly change. He was, in that sense, a luminary who left a profound and lasting contribution to the rule of law. Ram Jethmalani's first case was before the Sindh High Court. At the young age of 17, the enrollment rule prescribed a minimum age of 21 years, which prevented Ram Jethmalani from starting his legal career at the age of 17. Ram argued his own case before the Chief Justice of the Sindh High Court when he was a student of law, challenging the minimum criterion prescribed by the rule. He passionately argued before Sir Godfrey Davis that his parents would not have permitted him to study law if they knew that he would not be able to support the family for 4 years after graduating, in a sense. It was an argument of legitimate expectations, as we would have perhaps learned to call it several years thereafter. Ram clothed this argument of legitimate expectation with an emotional undertone, and it worked in his favor. Sir Godfrey, who was swayed by Jethmalani's persuasive skills, asked the Bar Council to amend the rules to introduce an exception. The colonial masters in those days didn't feel constrained by what we feel, namely the limitations on our jurisdiction to issue a mandamus to the legislature or to a subordinate to amend the law. It was right at that time, at a young age of 17, that both Ram and those around him realized that he was going to be a formidable force in the legal fraternity and who had the ability to take the courts by a storm. This early display of determination and commitment set the stage for a lifelong pursuit of justice. He came to Bombay, as it was then called, with all but rupees 10. As a refugee, he understood the plight of those at the fringes, especially the partition refugees. Just 3 years into his practice at Bombay, Ram Jethmalani made his first impression as a constitutional lawyer. He argued a challenge in the Bombay High Court to the Bombay Refugee Act of 1947, which granted extensive powers to the state government to confine refugees. Ram deemed it an affront to their dignity and passionately argued against its constitutionality. It was the first case that he argued after he enrolled as an advocate and went on to win it. Despite the recent adoption of the Constitution and a lack of guiding case precedent, he successfully argued that the legislature did not have the competence to enact such an excessive law. And he sowed the seeds of proportionality in his argument. He went on to appear before the Supreme Court in 1957, just 10 years after he started his practice in Mumbai. Even in his initial years of practice, he carved a reputation for himself as a brilliant criminal lawyer. In 1959, Ram was involved in the prosecution of K.M. Nanavati, Commander K.M. Nanavati. Commander Nanavati was an officer in the Indian Navy, handsome at that, who had settled down in Bombay with his English-born wife and their children. With Nanavati being away from home on long assignments at sea, Sylvia found companionship with Nanavati's friend Prem Ahuja. Sylvia confessed about her affair to Nanavati on his return from his assignment. Enraged by the confession, Nanavati went to the naval base to collect his pistol and then went to confront Ahuja. According to Nanavati's account, he had asked if Ahuja would marry Sylvia and accept their children. On hearing a negative response, he fired 3 bullets and unexpectedly, Ahuja just dropped dead. The case was tried by the jury, the last case that we ever tried by a jury in India. The issue before the jury was whether Nanavati shot the victim in the heat of the moment or whether it was premeditated murder. Ram was hired as a watching counsel by the sister of the victim. His role was to protect the victim and help with the prosecution strategy. There was a great Chari who was appearing in that case. The public prosecutor followed the line of questioning developed by Ram, and theatrical it was. He asked the surgeon on the stand why the victim would start the alleged fight without his glasses on, and how the 2 protagonists could have got into such a scuffle that the gun would go off accidentally with a towel wrapped around the waist of Prem Ahuja undisturbed. The case was sensationalized, and the jury was overawed with emotions for Nanavati and handed him an acquittal. However, if the judge wanted to send the case to the High Court for reconsideration, they had to prove that the jury was under wrong instructions. A decision of the jury could be overturned on very limited grounds. It was Ram Jethmalani who wrote the brief for the prosecution lawyer, then Mr. Y.V. Chandrachud, pointing out 8 instances of jury misdirection. The argument of jury misdirection was accepted. When the case was heard by the High Court, it found merit in the arguments of the prosecution and convicted Nanavati. But there's a story, there's a sting in the tail which Ram himself told me about. He said when the case opened, the entire court was hostile to the government pleader, namely Justice Chandrachud, who was then arguing the case. He says on the last day after the conviction had been rendered, Justice Shelat turned to the government pleader and said, Mr. Chandrachud, so are you pressing for death? Virtually indicating that if you argue for death, this was a case for the imposition of the death penalty. And we didn't have Bachchan Singh in those days, mind you. And the public prosecutor got up and said, my lords, I've got the conviction, but this is not a case for the award of the death penalty. And eventually, he was sentenced to imprisonment for life. The appeal against the conviction was also dismissed by the Supreme Court, but he got a pardon thereafter. There really began the friendship between my own parents and Ram and Ratna, which continued almost to the last day of their lives. Ram had the wit and vigor to work within the minute gaps and the gray areas of law. That is what set him apart from the rest of them. As a criminal lawyer, he was known for his art of cross-examination, bravado, and wit. He approached his cases with an investigative lens, an important craft for every criminal lawyer. He would ask for plausible explanations and give an astute psychological analysis of what a person normally would or would not do. Ram had that innate ability in him, which only the best of the criminal lawyers have, of recreating a crime scene. In 1988, he was appointed as amicus curiae to defend the person accused of assassinating Prime Minister Indira Gandhi. The trial court had convicted 3 persons for the assassination and sentenced them to death. The High Court of Delhi confirmed the death sentence. At the Supreme Court, as amicus curiae, persuaded by Ram Jethmalani's argument, a 3-judge bench unanimously not only set aside the death penalty, but also reversed the conviction of one of the accused, namely Balbir Singh. He would call this case one of his best forensic successes. The prosecution evidence relied upon a piece of paper supposedly found in the pocket of the accused with cryptic dates and names. Ram argued on the obvious foolishness of any person in carrying incriminating evidence after a month of the crime when public opinion was so heavily against the perpetrators. Ram gave it his all to prevent the execution of the other 2 accused persons as well. On the counsel of Jethmalani, the accused had petitioned the President under Article 72 of the Constitution to grant pardon, which was rejected. News broke out that the 2 men convicted of assassinating Indira Gandhi were to be hanged at 8 p.m. the next day. However, the hanging was stayed by the Supreme Court just 14 hours before the planned execution because Jethmalani had raised a constitutional question over the President's refusal to grant him a hearing. He argued that the pardoning power of the President cannot be exercised arbitrarily and that there must be guidelines for the exercise of this power because, as he remarked, secret guidelines, he said, are no guidelines. Though he was able to secure a short-term stay of the execution, he was unable to get it set aside. A month later, both the accused were hanged, but Ram's contribution should not be downplayed. He raised seminal constitutional questions in the course of the hearing, which went on to change the legal landscape on the death penalty. He couldn't protect his 2 clients from execution, but he protected the Constitution and the way it has evolved and as we know it today. I would even consider this case as one of the cases which sparked the extensive debate on death sentence in India. Ram Jethmalani was not only a formidable advocate, but also a passionate teacher. He started teaching at the Government Law College in Mumbai in 1953, an accomplishment that was no small feat for a person with no prior connections in the city. His eloquence, meticulous preparation, and deep knowledge made him one of the most sought-after teachers. Went on to play a pivotal role in the setting up of the National Law School of India University at Bangalore. Ram was beautifully networked. Whom did he not know in the political or legal scene? But he used his network for social purpose. He was a great friend of Ramakrishna Hegde, the Chief Minister of Karnataka, but he persuaded Hegde to give land for the Bar Council of India's National Law School of India University. In fact, he also went on to teach a course on the law of evidence at NLSIU for a term. His contributions led to the formulation of the 5-year integrated law program, an independent entrance examination for law schools, academic autonomy, and better quality education for students with a holistic curriculum. Ram Jethmalani would say that he would like to be remembered as a good teacher who could make a difference to the lives of the young. And difference he made. His teachings inside and outside classrooms, both at National Law School and at Symbiosis in Pune, which he was deeply fond of, continue to guide his students, his juniors, and even the judges, like me, who had the pleasure of hearing his succinct legal arguments. Ram, in that sense, democratized access to the legal profession. By setting up these law schools, legal education ceased to be the prerogative of those who are socially advanced or economically resourced. Legal education opened up for people without backgrounds, without family connections, without social capital, without cultural capital. Ram's unflinching sense of courage must also be remembered and celebrated. When the emergency was imposed in the 1970s, and when the civil liberties of persons were put on a hold, speech was censured, and arrest warrants were issued carelessly and callously against political opponents. Ashok Mahadevan, a young journalist of 26 years old, protested against the suppression of speech by publishing a 22-word obituary in the Times of India. One thing which I learned as a child was to devour the newspapers. And I still remember this obituary, which I must share with particularly the younger people here in the audience. And the obituary on the 26th of June 1975 read as follows. Hear it carefully. O apostrophe crazy, DEM, beloved husband of T. Ruth, loving father of L.I. Bertie, brother of faith, hope, and Justicia, expired on June 26. The young journalist, with the use of smart wordplay, protested against the emergency. The obituary actually meant that democracy, the loving husband of truth, loving father of liberty, brother of faith, hope and justice, expired on June 26. That is the day the emergency was declared. The legal community on many fronts, both inside and outside the courts, led the struggle to restore the rule of law. And Ram was at the forefront. He was the chairperson of the Bar Council of India during the emergency and was very vocal about his opposition to the emergency. In 1976, he spoke fervently against the imposition of the emergency and the curtailment of liberties while he had gone to attend the All Kerala Lawyers Conference in Palghat. Even before he could travel back to Mumbai, an arrest warrant was issued against him under the provisions of the Maintenance of Internal Security Act. No less than 300 lawyers, led by Nani Palkhiwala, went to the Bombay High Court to secure a stay of the arrest warrant. But the stay was good only till the Supreme Court pronounced its verdict in ADM Jabalpur versus Shivkant Shukla. While arguing the ADM Jabalpur case, Ram memorably reminded the judges that erosion of civil liberties spares no one in its wrath, not even the courts. Ram began his arguments before the Supreme Court by saying, "My lords," he said, "you will not be impressed by the fact that I am appearing for one detenue. Now I am going to tell you that I am appearing for all 5 of you." Like the outcome of this case, he witnessed many firsts and the lasts in the legal landscape, but his heart lay in strengthening democratic institutions. He never despaired by outcomes which were contrary to what he argued as a stated legal position. In that sense, he didn't have the ego of a person who believes he is morally right in everything that he argues, because he knew that he was arguing for a perspective which he believed in. During his legal career, which spanned over decades, Ram argued as a defense lawyer in a lot of high-profile cases, such as the Harshad Mehta market scams case, which, by the way, was fortunately the case which led the lawyers' fees to go out of the roof. The Hawala scam, the accused in the Jessica Lal murder case. When he was asked if he appeared for a lot of high-profile cases because it paid him well, he replied, "Of course, naturally," he said. He also went on to say that a lawyer who refuses to defend a person on the ground that people believe him to be guilty is himself guilty of professional misconduct. But Ram also understood that access to justice would be an illusion if lawyers charge exorbitant professional fees or appearances. He recognized the deep inequalities which plagued the society and was deeply concerned about the injustices meted out to the common citizen. By some estimates, he charged only 10% of his clients, and 90% of the cases were handled by him pro bono. I've actually witnessed him in the bar library of the Supreme Court Bar Association, quoting a fee virtually at the back of his hat, or the top of his hat, and asking for a fee of the unstatable. He also recognized that institutional reforms are required to enhance the quality of justice and access to justice. He once said that only perceptive practitioners sitting in court notice the frequent miscarriage of justice. Correction does not require legislation. Setting up traditions binding on the Chief Justice of the court is enough. So I thought I'd end the first part of my presentation by reminding myself that you do not require a change in legislation. Setting up traditions, binding on the Chief Justice of the court is enough. Ram was an amazing mentor. I'll just give you two little examples and I'll then go to the more formal part, and I hope not to bore you beyond that. We were doing a high-profile case and we were appearing for the chairman and managing director of a not-to-be-mentioned corporate group in India. In the Bombay High Court, an excise circular was placed before the court, and it so happened that the circular was fabricated. The judge in the Bombay High Court decided to initiate proceedings under Section 195 and 340 of the CRPC. And we came in appeal to the Supreme Court. And we were against one of the most hostile benches that you could imagine. And it made it worse for us because we thought that both the judges had a slightly pro-revenue stance in their ideology. The first part of the session, the morning session, Ram was subject to a hostile bench. We went back to his chamber for lunch, and we were extremely worried about what the outcome was going to be. So we asked Ram, well, what are we going to do after lunch? So he looked at me and said, for starters, we need to get some chicken patties from Wenger's. So order we did for some chicken patties from Wenger's. I don't know whether it was the patties or what happened, but after lunch, it was just sheer brilliance. Brilliance personified. In about 20 minutes, we had the judges completely turned. One of the most hostile benches came and said, well, we are allowing the appeal. As Ram evolved in life, many of his lesser-known clients had to go to the lesser-known lawyers because he was no longer fit enough to appear for them. And that's how people like me who were fledglings at the bar picked up the work. He introduced me to the Indian Express work. There were remnants of the work which had remained, the Customs Act cases of the emergency, which were still lingering on in the 1980s. And that got me an opportunity to go to Express Towers with Ram's juniors and to prepare pleadings. Criminal appeals, it was a sheer joy to sit with him. To sit with him even while drafting a special leave petition. I remember a case where there were about 14 accused. And he gave me a brief sitting of about 10 minutes to explain to me how a criminal appeal should be drafted. How you must analyze the role of every accused. Who were the eyewitnesses? What was the specific act, the overt act which was attributed to the accused? The topic of the day, of course, which Mr. Jethmalani has thought everybody should open up with, is about the Basic Structure Doctrine. Much as I admire Mr. Ram Jethmalani, one thing I wouldn't like to share with him is his ability to court controversy. So I thought that if I have to do something about this doctrine, I should do it through my judgments and not in an off-the-court pronouncement. So I've taken Mahesh's permission to talk about something a little different. And that's just about 5 or 7 minutes. The Supreme Court, which all of you probably don't know about. And let me tell you a little bit about the Supreme Court you don't know about, because you read about the Supreme Court in the electronic media, social media, they're trolling us every day, the print media, and of course the law reports. But let me tell you about the court which I would like to tell you about. The COVID-19 pandemic had just started receding when I took over as Chief Justice of India. I was aware of the huge responsibility which I would be shouldering. The pendency rates had increased because of the pandemic. Most of us had lost somebody dear. The pandemic had not only brought the world to a standstill, but also left emotional scars from which we are yet to recover. While I knew that I had to prioritize speedy disposals, I also knew that I had to prioritize the mental health of lawyers and registry officials by not pushing them to overwork themselves both physically and mentally. They are not poster persons of the justice delivery system, but they are certainly at the forefront, keeping the cart moving one day at a time. It is important that their efforts are recognized. My first goal as the Chief Justice of India has been to institutionalize the courts and move away from an ad hoc model of operation. Too often the problems with our institutions are that every individual who comes into the institution lays down innovative ideas only for those ideas to be forgotten after each of us passes on the baton to the next person. One of the important effects of institutionalizing courts is that it enhances transparency and accountability. While these are very important effects of institutionalization, we should also not forget the human side of the story. I have, in the course of my 10 months as the Chief Justice, realized that institutionalization, in addition to enhancing transparency, also humanizes the workspace. The staff are able to draw boundaries between work and home and increase their work efficiency. It has also positively changed things on those on the other side, that is the bar. We have implemented filing of cases in the electronic form, removal of defects, submission of urgent listings, and appearance slips, all through online portals in the Supreme Court. It's way more easier now to file pleadings than to live in the anxiety of standing in lines, waiting for a person to mark defects on the file and returning it to be filed afresh. Citizens can now also find out the status of their cases instead of having to rely on their advocates, who, because of their busy schedules, may not always relay the update. Of course, this is a change, and changes don't come easy, but it is a change worth making for enhancement of the justice delivery system. At this point, it is necessary to emphasize that when I speak about enhancement, I do not limit the reference to quality judgments. My focus is also on reducing barriers to accessing the courts, easing the process of filing and arguing before the court. My focus is on improving the gender ratio of lawyers. My focus is on ensuring that lawyers and litigants have facilities to comfortably rest while at court. It is only with such an holistic approach that the quality of justice delivery could be enhanced in every sense of the word. The Supreme Court is bursting at its seams. Our building was constructed in 1950, and we have moved the government with a blueprint of a new building to replace one of our older buildings which were constructed in the late 1980s or 90s, and to have a modern Supreme Court building in the same complex with 27 courtrooms, bar association spaces for the women lawyers, for the Supreme Court Bar Association, for the advocates on record, and above all, for our litigants. One of the primary requirements for institutionalizing the court system is to identify the issues that hamper our efficiency and curating remedies to address such issues. An able team of judges, lawyers, and researchers working at the Center for Research and Planning are assisting the courts with this work. Their work is invaluable, particularly because of the lack of research and data on the functioning of courts in India. The Center for Research and Planning is now in the process of creating a system for managing and reducing the case pendency through a project called SC Judicare, which stands for Judicial Disposal through Case Management and Resource Efficiency. The project aims to increase efficiency through improved case classification, grouping, and tagging. Phase 1 of the project is underway, where we have collected data on pending dockets to frame guidelines. We have also prepared a roadmap for auditing criminal matters. Our aim is to integrate granular data with integrated case management information systems, identify infructuous matters, and devise strategic priorities at an institutional level. Let me also deal with one of the criticisms which I hear, and I look at criticisms in a very positive and optimistic perspective. Because if you look at criticism cynically, you can never improve your institution for the better. One of the criticisms which is expressed about the collegium is that we have no factual data to evaluate people who we are considering for appointment to the Supreme Court. I just wanted to share with you some of the steps which we have taken. It's still work in progress, but we are improving. I have a Center for Research and Planning. The Center for Research and Planning is headed by an officer from the Haryana Judicial Service with two very distinguished young scholars and a number of young people, interns, law researchers who come and work with us for 2 years. We have prepared a dossier. I shouldn't call it a dossier, but we have prepared a broad platform where we have assessed every one of the top 50 judges in the country who would be considered for appointment as judges of the Supreme Court. We have data on judgments. We have data on reportable judgments. We have data on the quality of judgments which judges are delivering. The idea is to make the process of recommending appointments to the Supreme Court more transparent. Not transparent in terms of sharing our discussions in the public realm. You can't obviously do that. But by laying down objective parameters for selection both to the High Courts and to the Supreme Court. Yesterday, the Supreme Court got on board the National Judicial Data Grid, which would provide real-time tracking of disposal and pendency with a click. This will increase inter-court coordination of data and aid in conducting quality research. Disposal and pendency of the Supreme Court is now available case-wise, year-wise, stage-wise, and quorum-wise. This information will help the court to identify areas of concern to decrease pendency. Institutionalization requires policy solutions. Due to the lack of data, it has been painfully difficult to devise methods to reduce pendency. Now, we know according to the NJDG data, there are 62,946 pending civil cases and 17,555 pending criminal cases. We also know that 15,000 cases have not been registered as yet, which means that the lawyers have still to get these cases ready for hearing. So the actual pendency is in the vicinity of 65,000, with 15,000 cases not really in that stage of being pending judicial cases. We have had a disposal rate of 95.34% this year. Our court has disposed of 95% of the cases which have been instituted this year. This data will help me prioritize certain categories of matters, such as the oldest pending cases, for their able disposal, and would allow us to introspect our performance in terms of disposal throughout the year. Another significant step that we have taken is to make the Supreme Court and High Court judgments available through the eSCR portal. When I started litigating way back in the 80s in the Bombay High Court, we used to get the All India Reporter or the Supreme Court report volumes upon subscribing to their print editions. We would wait to see the latest development in law and would be so thrilled to find a senior's office or a court library with an up-to-date record. In our common law system, court precedents are a vital source of law. Now there are online databases available, and the printed AIR and SCC records have become decorative books in law chambers. However, many young lawyers and law students find it difficult to subscribe to online databases because of the high price. This creates a professional barrier for young graduates, particularly from those from marginalized communities, such as the scheduled castes and the scheduled tribes. But the difference between my days of legal practice and lawyers starting out today is that dissemination of information is no longer priced. What was once impossible is now a reality. More than 36,016 Supreme Court and 11.6 million High Court judgments are available on the eSCR portal and the free text search portal of the E-Committee of the Supreme Court. The portal allows free text search of judgments by providing a combination of various search options and keywords. The embedded filtering feature allows further filtering on available results. The eSCR project was devised with the aim of providing free access to judgments so that a person's financial standing or institutional affiliation does not unfairly restrict them. In that, we must think of Ram when he came back from Sindh, and not Ram as that very highly resourced, extremely brilliant lawyer at the top of the career. We cannot pretend that these issues do not exist. The eSCR portal is a challenge to the mindset that one requires financial standing to make quality arguments. I implore all the lawyers here to start using the search portal. If any of you have ideas to better the services provided by eSCR, kindly reach out to my office. We are now also moving to a paperless mode of pleadings and communication. Courtrooms of the Supreme Court are becoming tech-friendly. In courtrooms 1 to 3 of the Supreme Court, the law books that once marked the perimeter of the room are replaced with e-libraries. Digital display systems have been installed for judges and advocates. In the Constitutional Bench hearing on the challenge to the abrogation of Article 370 that concluded recently, we saw a record of 47,835 pages of paper book, case documents, case law, compilations, and written submissions of the petitioners and respondents, all of them were scanned and digitized to allow a paperless bench and a largely paperless bar. I like to practice what I preach. In my office, all communications for approval with the registry, even internal notes take through the paperless mode, through e-office. When I took over as the Chief Justice, I realized the sheer frequency and volume of approval that is required for every decision taken by the court staff and the registry, including the flowers that are put in the foyer of the Supreme Court. Each time the staff would come to me with a stack of papers to peruse only for a signature, I took a call and asked the staff and the registry to send over e-documents, which are now e-signed by me. I'm not sure how Ram Jethmalani would have reacted to these reforms. But I thought I should mention this because I know that he is sitting up above the twinkling stars, he and Ratna, with my own parents, Yashwant and Prabha. True to his maverick pedigree, he would have given further suggestions for improving court's efficiency and reducing case backlog. He touched us with the genuine concern he shared for the systems he inhabited. A fitting tribute to a person like Ram is that we too continue to be concerned and be a part of change in the systems we inhabit. The way I see it, he was not just concerned about what he found, he was more interested in whether he left it better than he found it. It has been a great honor reminiscing the legacy of Ram Jethmalani, one of the greatest of our times. Thank you very much.